juror 14 and juror 15 and they look the same, you've got something, some kind of evidence to make that choice. And then that person you have taking notes for you, when the jurors get selected, write down who those jurors are. If you don't keep the juror information card, write down the particulars. Know when you're doing your closing argument if you're talking to lawyers or engineers or teachers, and know who they are so that when you're putting forth a particular point, you're speaking to that juror. If you've got teachers on your panel who I think are great, for defense lawyers, they like to make sure all the dots are done, all the T's crossed, right? And if you're ticking it off and the state hasn't got there, that teacher can help you. But they also know kids. So if you have a young client, you can talk about things they will understand. Make them on your team so that when they're in the jury room, they can help you and say, this is how kids act, this is how they think. Okay? Now sometimes you're trying your case, let's say you're trying an aggravated robbery, and so perhaps the identity is weak. So you want to argue for the jury to find your client not guilty because the state hasn't proved identity. I think the jurors you want there are folks who are willing to stand up to the state. Strong jurors, right? But those same strong jurors, if they convict your client, are going to want to hammer them at punishment. That's a balance. Know who your jurors are and know who you're arguing to. When you are doing your closing argument, I think it is important to acknowledge what your weaknesses are and not to ignore them, to put it out there. Everyone, of course, tries their case differently, and I've seen it done a million different ways, and it turns out that most of the time it's right for whoever the lawyer is. I've seen some lawyers who challenge every single thing, object to everything the prosecutor is doing that's wrong. And then I've seen those lawyers who only attack the weak spots, let the other stuff skate, right? And then just attack the weak. Y'all decide how you try your cases. But no matter what you do, be sure that you address your weaknesses. Don't ignore them. Because the prosecution gets the last word every time, and they're going to drive a truck through it if you don't talk about it. By the same token, if the state's weak, if they've got a point they can't address, you know they can't address it, then call for the prosecutor to answer. Okay? Ask him for an answer. Maybe they answer and it looks weak. Maybe they ignore it. Those jurors will be looking for them to do that. Be careful how you go about things with the complainant. If you have a sympathetic complainant, or if the offense is upsetting or troubling, or everyone in the world has sympathy for the complainant in the case, then acknowledge that. Show empathy for the complainant. It doesn't make you weak, it makes you human. Let the jurors see that. And you can follow it up by saying, of course, we have sympathy for the victim in this case. But justice is not about deciding on emotion. Right? That's the mistake the police made. They got so caught up in how terrible the offense was that they didn't carefully investigate. They picked the most obvious suspect rather than doing the research. Don't make the same mistake, right? There's a reason Lady Justice is blinded. Acknowledge the sympathy, but talk about why your client shouldn't be punished because we feel sorry for this person. Don't capitalize on the tragedy by convicting someone innocent. Okay? I recognize that sometimes it doesn't always go the way that you want. it's very easy, especially if you have a client who is innocent or you have a case where the state's case is weak, to focus totally on winning. And my favorite quote from Clarence Darrow is that the courtroom is a place where men go not to seek the truth, but to win. And that's right. That's why we like this. We want to win. But sometimes you don't win at the guilt-innocence phase. I see some of the capital lawyers there, and I'm thinking, hardly ever. Though a few of you have, right? But you got to prepare for the punishment case, and not just if you're the capital lawyer. So the argument that I have prepared has to do with a young offender convicted of aggravated robbery, where I thought that I was going to win. And I'm going to argue to my jury over here. Please forgive my notes. So I have a difficult task here. You know from the voir dire process that this is the punishment phase, the second mini trial that we have. But I have to give you an argument that I never believed I would be giving, that I never intended to get to. And while I appreciate the hard work that y'all have done, I disagree with your verdict, but I respect the system and the jury trial process. But essentially, you have told me that you don't believe us. You don't believe Joshua when he told you that he didn't do it. So we're at the penalty phase, and you have to decide how you're going to punish Joshua. Now, for this mini trial, if we go in chronological order, the state has presented you nothing. Now, I would anticipate the state would object and say, it's a misstatement. They reintroduced all of the evidence. Okay, so that got sustained against me. That's right. No new evidence has been presented. No better evidence. What we have is a robbery, a co-actor we didn't hear from who says Josh was his co-actor. You've got the interview of Joshua. Now, I concede in that interview, Joshua was not respectful, and he used colorful language. In hindsight, it's like he almost knew that it was a game-ending accusation, that he was powerless. To be fair, how many of you know where you were 6 weeks ago at 11 p.m.? And you have a tentative ID from a store clerk where you know Joshua has been before. This is in his neighborhood. His friends live nearby. That's the evidence that you have from the state. What do you know about the defendant? Well, you heard from his mother, and of course, she doesn't believe that her son committed the offense. But how strong was she? How credible was she to testify at her son's trial? Be subject to a prosecutor who has no empathy, to talk to you about her son. What did you learn from her? She had all of his report cards. Don't you know when she was saving those report cards and that artwork from the refrigerator that she was never thinking she was going to use those documents at a trial? Now, of course, the prosecutor objected to the mother's report cards, and they're entitled to do that. So we brought in the custodians of records from the elementary school and the junior high to authenticate those report cards that Miss Williams had, and they were exactly the same. Maybe it was the written notes about Joshua being a ray of sunshine in 4th grade that they wanted to keep out. Maybe it was the conduct, the consistent conduct. He wasn't getting E's all the time, but it was always satisfactory. Never suspended from school, no fighting. Now, he wasn't an A student, but he was an average student. The reason that moms keep report cards and artwork is because it's important at the time. He's special to her. He is a special person to her and to his brother and sister. You also heard from his basketball coach. You also heard from his supervisor. Now, he's only been working for a little more than a year before he gets picked up. But he's a hard worker, working for that maintenance company that owns those warehouses where he goes and does manual labor, mowing lawns. That's not easy work. And while we're on the topic, do you remember your first job, what you did, and why you did it? Was it for spending money or gas money? Joshua Williams doesn't have a car. His family doesn't have a car. The money he earns goes to keep the lights on in his house, to take care of his family, put a roof on their head, over their head. He's acting like the man in that family. State of Texas says he's an adult. You know, he was 17 when he was arrested. He was picked up at school, for crying out loud, and put into a cell where he has been until his trial. When he should be learning American history and algebra, he's in custody. Do you have contact with anybody who's 17? Do you have kids that are 17? Or do you remember what it was like? When you are 17, you are thinking like a child, you believe like a child, making choices and decisions like a child. Now you're being asked to sentence an adult, but he's a kid. When he should be learning in high school, don't send him to TDC to learn there. What are you learning in TDC? Survival. Learning how to avoid being a victim. Learning about things that polite people don't talk about. Don't do it. He is a convicted felon. By your verdict yesterday, he is a convicted felon for the rest of his life. He cannot vote. He cannot get a job where a license is required. He can't go to college and get federal financial aid. He can't serve on a jury. He can't rent a home in the place of his choosing. Now, I know the prosecutor's argument's going to be, we got a place for him to go and live. Won't cost him anything. Don't believe it for a second. It costs him everything. Don't send him to prison. I'm asking you to sentence Joshua like a parent would discipline a child. Teach him a lesson if you must, but do so with mercy. Do so with the idea of teaching the lesson and not hurting the child. I'm asking you to assess him the minimum punishment of 5 years, and I'm asking you to suspend that sentence. Thank you. Michelle. Thank you.
Thank you, Judge Bond.
Thank y'all so much.
Thank you.
Josh got found not guilty early on.
Say,
All
right.
All right. Well, next up we have David Mitcham. David Mitcham has been practicing for over 30 years. And David has tried over 200 cases, actually. And he's a lawyer that I think goes around unassuming, never really looks for a whole lot of credit, doesn't brag or boast about any of his victories. But David has won a significant amount of trials. I want to argue that David has won over 100 trials. I remember reading somewhere where David had over 100 criminal defense cases that he had handled that ended up in positive results for his clients, either not guilty verdicts or dismissals following trials. Is that correct, David? There's been over 100 cases of not guilty verdicts, which in and of itself is incredible. Most lawyers don't even try 100 cases, let alone win 100 cases. Now, these aren't only DWI cases that David is trying and winning. I looked them up, and he's won multiple murder trials, which is something that only a handful of lawyers can claim. I mean, there are a lot of lawyers who practice 30, 40 years, try murder cases and never win murder cases, but David has won multiple murder cases. And he was at one time, and this was back in, I think, like the late 80s, listed as one of the top 10 lawyers in Harris County. And so without any further ado, I want to bring up for you David Mitcham.
Thank you for your kind words, Eric. I appreciate it. And I've been doing it for 37 years, so it gives you more time to go to trial, I guess. I'm glad to be here amongst my many friends and colleagues of the bar. Many of you I've done trials with, as a matter of fact. Wayne Hill here was my supervisor when I was at the DA's office.